When should I file a patent application?
So the next question I get a lot is, when should I file a patent? So that I've got too early, too late, and just right. And it's important that you know this. And a lot of people come to me either too early when I can tell them to wait, or too late when I have to say sorry. So too early is immediately after you come up with the invention. And the reason is you need to enable it. I'm working with an inventor right now, actually, who had a great idea, who we searched because we had enough information over a number of calls to search. So I believe it's patentable, but doesn't even have the first drawing. So it's not enabled, it's too early. You can't just come up with an idea and file a patent at that moment, because if you file it too early, there's no enablement, you're never going to get a granted patent. The other thing that is, it's sort of a nuance, but it's important, is when you file a patent application, you have exactly 12 months from that filing date to file in other countries. And that's it, you're done. You can't wait till 12 months and 1 day. So if you file too early and your business, you don't even have the product ready to go, you don't have any income, you don't have investors, and now it's 12 months and I'm saying to you, we got to do this now. You have to make some decisions, right? It can be kind of uncomfortable. And I've had many inventors who just say, you know what, I'm just going to stick with the US, or I'm just going to stick with whatever country that we had filed in. So too early can actually work against you. Too late is after public disclosure. So if you have an idea and you've been working on it for a really long time and you've told, well, maybe when you were talking about patents, you told everyone in this group, you have another same amount of time, exactly 12 months in the US, not all countries are the same, to file the application. So if 2 years ago you had this great idea and you sketched it all out in your logbook, or you drew it on, you know, put together some things, and it was 2 years ago, and then in a coaching group you shared it with everyone to see what they thought, if it was a good idea, you can no longer patent it. It's just done. So you have to be careful. The other thing is, even though countries like the US give you a 1-year grace period, not all countries. There are countries that are under systems called absolute novelty. China's an example of that. There's many others. And they actually say, if you even tell one person outside of, you know, your confidential group, you can't get a patent. So just right is when you've enabled it, even if it's just on paper. I know I said it's approved for commercial production, but it could just be it's ready. You have a lot of my current clients aren't ready for commercial production when I start work, when I actually file the application, but there has to be enough there that we know it works, or we believe it works, and prior to public disclosure, or at least prior to the 12 months.